Today we'll discuss how you can apply for a visitor's visa to come to the UK. In order to obtain a visitor's visa, you must meet two things: the suitability criteria and the eligibility criteria. First, you must make sure that you don't fall for refusal under something called the General Grounds of Refusal, Part 9. In terms of eligibility, you must show your intention. You must prove your intention. You must show that at the end of your visit, you have the intention of leaving the UK. Most applications are refused because, based on evidence or lack of evidence, the entry clearance officer decides that you don't have the intention to leave the UK at the end of your visit, and the application is refused. You have to demonstrate that you will not make the UK your main home, that you will not stay in the UK beyond the permitted period of time, and that you really want to come to the UK for the sole purpose of being a visitor. You will not work, and you will not do anything that is not permitted. You have to show that you have the money to spend, and you can spend the time in the UK without the need to work. What evidence can I prove to show my intention? How do you get into my head and decide, yes, I intend to be a visitor? My advice to my client is always, think about it. If you went to the bank and said, lend me the money, I'm good for the money, what would you prove? You will prove your assets, your connection, your business plan. Similarly here, prove your connections to your country of origin. I have left my mother behind. I have left my wife behind. I have 2 children in school. I have a business. What is the purpose? I'm coming to watch football. I'm coming to my sister's wedding. Show how much money you have in the bank. I have lots of money. I'm coming to do shopping. Show your past record. I always come to the UK and I never overstay. I'm actually coming for a grand tour of Europe, and this is one of the many stops. I have a return ticket. Show your intentions, show your pattern, and show that you have the reasons something is pulling you to go back to your country of origin at the end of the visit. Many people ask me, what if I have a sponsor? Why do I have to show my own money? Because showing your means also shows your intentions. What happens if your application gets refused for a visitor's visa? There is no right of appeal. What can I do? If you believe that your application was refused because you did not provide enough evidence, why don't you give it another go? Make another application. Think what it could have done better, what evidence was not submitted, what did the Home Office say I did not submit. But if you think that you've done your best and the decision is unlawful, then you can challenge the Home Office. But this challenge is expensive and complicated. The first way to challenge the Home Office is to submit something which is called letter before action, or in other words, pre-action protocol. Let us take our time to understand what is a letter before action. A letter before action is a letter that sets out the basis on which you disagree with the decision, and you are saying to the decision maker, I disagree with you, and I would like you to review it. And I would like you to review it within 14 days, after which I will try to apply for leave for judicial review, to go to a higher authority, to the High Court, to look at the decision and to decide if it's irrational, if it's unlawful, or if it's discriminatory. There is a particular format that you have to complete the pre-action protocol, and I'd be very happy to discuss it with you if you wish. In this letter, you have to write exactly the reasons that you don't accept the Home Office finding. The Home Office did not give sufficient weight to some of the evidence. The Home Office ignored certain principles of law. You have to say why you're challenging it. If the Home Office does not accept or change their mind after the letter before action, then you will have to seek legal advice as to how to apply for leave to judicially review that particular decision. But the judicial review will be not because you don't agree with the findings, but because there is a serious misdirection and the decision is unlawful, irrational. The Home Office usually has 14 days to respond to the letter before action, after which, if they maintain the decision or change the decision, you'll be able to make an informed decision as to what's best next. If I can help you in any way in bringing your family together or making a successful visitor's application, please don't hesitate to contact me. We offer free Zoom consultations, and all you have to do is drop us a line, make a phone call, use the contact sheet on our page. We will get back to you and have a chat free of charge. Thank you very much.